move?
I move. It's a very unfortunate way in this bill that a number of complex issues are conflated, and by that I mean that there's a conflation in the construct of this bill, I think, with the issue of trafficking, with the issue of coercion into sex work, and to a degree the issue of pornography. But they're all very different issues. And the justification for this bill largely rests with what is known as the Nordic Swedish model of legislation. But I do think that this bill fails to understand and recognise that the most recent research into that model raises very profound questions on the issues around criminalising the buyers of sex. Now, in my trade union, Unite, we had a major debate in the Women's Committee on this issue a number of years ago, and I was a lone voice actually opposing the Nordic Swedish model on the basis of the arguments I'm about to make. And at the time, these arguments were rejected by very progressive women in the trade union, who are now having a complete rethink on the attitude of the union to their response to the Turn Off the Red Light campaign at the time. And I think that's very fair and that's a very intelligent thing to rethink, because the evidence and the research and indeed arguments made by groups like Amnesty are now showing that actually purchasing or criminalising the purchase of sex is going to drive sex workers into more dangerous and precarious lives, and it is going to increase their vulnerability, and has done so in the areas that this model has been brought in. So effectively targeting the purchase of sex is driving sex work underground, and it means that the clients who are now in a position to demand more structures around how the act that they are about to purchase takes place, where it takes place, the sort of safe places that they will demand to buy the sex in, or to have the work performed in, will mean that sex workers are even more vulnerable than they already are in our modern sort of living. I want to quote from Amnesty, who looked at the Nordic model and talked to sex workers and arrived at the conclusion that it would be much, much better for sex workers to decriminalise all aspects of sex work. In this Amnesty report, a larger problem that befalls sex workers from this kind of criminalisation of the buyer, and they look at what happened in Norway and a pattern of things like police surveillance of sex workers, evictions and deportations, particularly of migrant women who in some cases rely almost totally on that form of work. And they find that because sex workers are now, if you like, being used sometimes as evidence in court to criminalise or to find a conviction against a buyer, things like carrying condoms can be used as, if you like, an Exhibit A or B in a court case, so they tend not to carry condoms as much as they would have done before the purchaser of sex became the criminal. And in such instance, obviously, it doesn't have to be really stated, that not protecting yourself while you're carrying out a sexual act, particularly with a stranger, is extraordinarily dangerous to your health. And this has led, in many cases, to an increase in sexually transmitted diseases, etc. Reporting violence, reporting aggression, reporting attacks has decreased by sex workers, because they find that if they have found that complaints that they make to the police often leads them to being more and more harassed themselves. And so there's no evidence that these laws of criminalising the purchaser actually lessen the discrimination, the stigma and the violence faced by sex workers. And in reality, the Nordic model has increased the danger for sex workers. So I think there's an urgent need for looking at the evidence that is produced by many surveys, and Amnesty's one is particularly useful and is particularly broad. So they say, for example, that there's the utterly disgraceful situation of women seeking asylum that are often the fact that the sex work is often used against them to evict them sometimes, and sometimes to deport them. So I want to argue that this bill, if we were to bring it in here, would create all those dangers for sex workers here, and particularly for sex workers living in direct provision, or sex workers who are refugees or migrants here. It does increase their risks. It drives the whole business underground even further, and it does nothing to deal with the reality of their lives. So it will heighten any prospect that they have to be at the wrong end of the law and the wrong end of the court. So the Norwegian government's own research found that criminalising the purchaser has had the effect of strengthening and increasing the dependence for migrant women or migrant workers and migrant sex workers, dependence on traffickers and the exploitive third parties who often, as I say, we'll come to it later on when we look at the section that wants to outlaw brothels and sex workers working together in groups of more than two, that there is very much evidence that the driving underground of the sex work as an act, as a function, also leads to making sex workers much more vulnerable. So this bill would worsen both the lives of sex workers, it would increase the danger of the work that they do, and it would increase the danger to their health. What we'd like to see, and the whole purpose of deleting this whole section, is that all aspects of sex work is decriminalised, all aspects of prostitution, both from the purchaser and from the sex worker, is decriminalised. In that way, if we were to reach a point where we accepted that as the sensible norm, in that way we can then start seeing our responsibility to be really about making a bill that provides supports, both educational and functional supports, to people who may feel that they're purposely driven into sex work rather than choosing it as a lifestyle. So I think we're going about this completely the wrong way, and this is why we're arguing for the deletion of the entire section.
Thank you, Deputy Jonathan O'Brien.
I don't mind if some of the others want to speak first. This is their amendment. I can go after.